Good afternoon, ladies and gentlemen. It is now 5 o'clock, so we're going to start with the second webinar. I've switched on my camera so that you can just see that I am a living person, but I'm going to switch it off while you see my PowerPoint. And then when we get to the questions and answers, then I'll switch on again. But all of you, please switch off your videos and mute your microphones, please, just out of courtesy for all the rest. And then also just a few housekeeping rules. Let me finish first. Let me finish the lecture, and then you can ask questions so that those of you who want to leave can leave. But I'm in no hurry, and then I will address all your questions. So just make notes of things that you would like to ask me, and then we can answer it afterwards. Okay, just all of you switch off your videos and mute your microphones. Can I just find out, can you see the PowerPoint? Is it visible to all of you? Can someone just indicate to me, can you see the PowerPoint?
Yes, we can see that.
Okay, so yes. So while I speak, you can make notes. You can even post the questions if you want to. I will address the questions in the chat room when I'm done. But don't interrupt me so that we finish, and those of you that want to go can go. And thank you for all of you for joining today. I am so sorry. When we did the planning, we didn't take into consideration that this is an evening before a long weekend. So apologies for that, because I do not have children in school anymore. I tend to forget when is it public holidays, etc. So thanks to all of you that is in the class today. And remember that the PowerPoint will be made available immediately afterwards, although the recording, you will not get the recording, but you will get the PowerPoint. Okay, so I'm going to switch off my video and I'm going to start, and then once we have the questions and answers, I'll switch on again. So all of you, your videos off and your microphones muted. Okay, so today is the second webinar. Last time we had the first one, and I think last time you were all still very new. You didn't know what's going on. I think now it is much better. You understand now what is going on, and I think maybe the majority of you have also written test 1, which means that you have gone through all the study material and you are now more or less on the same page as I am. And I am sure you are busy with your activities, so you can ask any questions, but I think you will understand in this webinar much more what is going on than in the first one. So just by way of introduction, you are just one group doing this this course. Usually we have 2 groups, but this semester we only have 1 group. And it is facilitated by myself, Professor Magda Slabbert, and Bonnie Venter, which I think you know, because Bonnie does all the announcements and the uploading of the activities and the answering of the questions, etc. Remember that when you have an administrative issue, you must please contact Grace, because we cannot help you with that. And the previous webinar was on the Constitution, and I started, we sort of as an introduction looked at the law of contract and the law of dealing. So we're going to go forward today. And from my side, I think today is the most important, because now we're dealing with the actual medical negligence and what does it imply, etc. Just a little bit of a few extra general matters. Keep an eye on your schedule, that you are aware when you have to submit your portfolios. Remember, portfolio 1 is activity 1, 2, and 3 put into one PDF document and sent, uploaded on the system so that it can be marked. And then activity 4, 5, and 6 is portfolio 2. Also remember that Bonnie is online once a week where you can ask questions. If Bonnie can't help, she will contact me. If I can't help, I will find out. Then read all the things that we put under announcements. You will not be tested on it. It is also not relevant to the activities, but I've given a few documents to Bonnie to upload under announcements. That is extra information. That is extra reading, and maybe it can be useful for you to remember. This is an introductory course. So, and we go relatively fast. So if you want to know more, it's always good to read some of the academic articles written on certain topics. So Bonnie has posted it there. It is only for your own interest. It is not prescribed. You will not be tested on it, but it is good to take cognizance of. And then I think by now you are in a certain rhythm. You have to do the activities as you receive them. You receive an activity every week. Otherwise, you're going to run out of time. You have to plan your time. Remember, you can ask questions for your fellow students on the forum, but you must, at the end of the day, submit your own work. And remember, speak to us if something goes wrong, if you are involved in a very important case and you can't get to do the activities or whatever, please speak to us. Bonnie and myself will make a plan and see how we can accommodate you. But don't give up. You've paid a lot of money for this course and you are now thus far. So don't throw in the towel now because something happened personally in your life. Speak to us and we will see how we can accommodate you. Okay, then remember that the portfolios contributes 80% of your final mark. In other words, it's 6 activities. All 6 of them is for 50 marks. Then we rework the marks for a mark out of 80%, and test 1 is the other 20%, and then you get your final mark. And last time I've also indicated, and I think you've noticed now, that the questions for the activities are broader than the study guide. In other words, you cannot find the answer in the study guide. You will have to read the prescribed case, and then you will be able to answer the questions. As I've said, you should ask if you need help. And then just there highlighted in yellow on that slide. Last time we had a huge discussion about pain and suffering. And I explained to you that when your child that you are supporting dies because of negligence, you have no claim because there's no damages. And a lot of you then questioned me and said, yes, but what about your pain and your suffering? And I told you that pain and suffering, you cannot quantify it and you cannot claim for it. But if your child goes to hospital and he ends up being a paraplegic because of negligence, then you will do it on his behalf if he's still a minor, but then there can be a huge claim. So because of all the questions, there is a reference to a case, Bele versus the MEC for Health, Gauteng, and in that case, as I've said last time, 100,000 Rand was awarded for pain and suffering of a woman who gave birth to a stillborn baby and how they treated her afterwards. But it's worthwhile going to that case because in that case, the judge quoted other cases where certain amounts were awarded for pain and suffering. But as I've indicated, these are extreme exceptions. So that when let's say your mother of 86, she's not supporting anyone, she's a pensioner, and she goes to hospital and she dies because of negligence, there's no claim. Because at the end of the day, you cannot prove damages. Although all the children will feel the pain and will cry and be angry, it's not worthwhile instituting an action because you will not be able to prove damages as she did not support anyone. So that's why I highlight that one, is just because of all the questions I got and that people cannot really understand why not. It's all explained in that case, and it refers to a few other cases. Sorry, I'm just taking a sip of water. Okay, now let's talk about the activities, because you have done, I think, the first 4 already. So I just want to make certain comments. The first one that I asked, the ES versus the AC case, that was the Namibian case. And what I wanted you to see there is specifically the directive that a person can give before death, what should happen when he or she is in such a situation that he or she cannot take a decision of their own medical care, that whole issue. And then I wanted you to see the balancing of the human rights, the right of autonomy of the mother and her religion versus the best interests of the children. I think it was quite an interesting case, and I hope you enjoyed it, but you're welcome to give feedback and say you didn't learn anything or the case was boring or whatever, because I just choose them at random if I feel it is necessary to make a point which is not made in your theory. Then the next case was the NC versus the Engelbrecht. There I specifically wanted you to see the difference between wrongful pregnancy, wrongful birth, and wrongful life. Because that you will get when you go into a medical negligence practice, that one of these cases might come along. And briefly, because you've done this, so I don't want to waste your time because you've already done the activity, but briefly, wrongful pregnancy is when you went for a sterilization, either a vasectomy or the woman for a laparoscopy, and something went wrong. In other words, the doctor did not perform up to standard. You went home thinking that you are well protected, yet you fall pregnant again, and then you can claim the upbringing of that person, of that baby. You can claim for that because you were not supposed to fall pregnant again. Remember the but-for test. But for the negligence of the gynecologist who did not sterilize you, you became pregnant again, and therefore they must now pay for the upbringing of the child. Sorry, I'm just fiddling with paper because I want to refer to a case which I will do just now. Wrongful birth is when a woman goes and asks for specific tests to be done to make sure that the baby will be normal. In other words, will not have spina bifida or will not have Down syndrome. But because of the negligence of the gynecologist to look at the test or interpret the tests, he does it wrongly, tells you that you are expecting a healthy baby, and when the baby is born, the baby is not perfectly normal and maybe suffers from Down syndrome or spina bifida or something else. Then you can sue the gynecologist if he did it negligently, and then you, as the parents, sue on behalf of the child, but you sue in your own capacity for the money to look after this child, for all the therapies that the child will need, etc. In other words, it's the parents saying this baby shouldn't have been born. But for the wrong information that they got, they now have a baby, and then they can claim. The most interesting one between those three is the wrongful life claim. The wrongful life claim is when the baby, the child that is born, claims that he or she should not have been born. It sounds difficult, but it is in the child's name being represented by the parents. So the child say, but for the negligence, I would not have this life of suffering. And then when that is entertained, then the money goes to the child. It's the child's money. In wrongful birth, it goes to the parents. Now, wrongful life cases for many years were considered contra bonos mores in our legal system, because the argument was, how can you weigh up the value of a normal life versus that with a disability? It is just against morals to do a thing like that. But then there was a case in H versus the Fetal Assessment Clinic. And there the Constitutional Court said that our legal system now allow for wrongful life claims. It must still be proved. You must still go to the High Court and have your evidence, etc., and prove causation, that there was negligence on the side of the gynecologist. But then when damages is awarded, it is for the child and not for the parent. So I wanted you to see that difference in that case. Before I carry on, Caroline, if you can just switch off your video. The reason why we switch off the videos is to save data. Thank you so much. Okay, then the third activity was the Van der Walt case, and that I specifically wanted you to see because that was a criminal case. That was where a gynecologist was charged criminally. Remember, nearly all other medical cases that we are dealing with in medical law are civil actions. It's either between a patient and the NEC if it's in the public sector, or between a patient and a doctor in the private sector. But the Van der Walt case is an example of a criminal case. What is very interesting about the Van der Walt case, and I want you to be open for this, you will hear it in television discussion programs, you might see it in newspapers, you may hear it over the radio, that people are furious and angry that doctors should be held criminally liable. The general feeling of the public is that a doctor should never be criminally charged, whereas Van der Walt was. And you will specifically get the Association of Gynecologists that say that they actually want a law to say that no doctor can ever be criminally liable. I completely disagree with that. And what always amazes me, and I want you to be sensitive about this, very few people have read the case. So they just generally in the media will say, it is terrible that doctors must go to jail, or that doctors must go through a criminal trial because doctors only do their best, etc., etc. But I think you should agree with me. If you read the Van der Walt case, maybe it's just my feeling, but what he did was not right. So what happened to him, according to me, he deserved. So unfortunately, and this was the other thing that I wanted you to see in that case, that the magistrate made a mistake. And because of that, they went to the Constitutional Court, and because of the judgment of the Constitutional Court, everything, he is not acquitted. The case is just null and void, and it is now up to the prosecuting authority to decide whether they're going to start a whole new case or not. But I hope you enjoyed reading the case, and I hope you didn't enjoy it to see what he actually did. And what was also interesting about that case that I wanted you to notice was that he didn't testify. And I don't understand why not. So at the end of the day, the only witness was the mother and the mother of the woman who died. So her testimony stood, because Van der Walt, the doctor, was never in the dock and he was never questioned, which was strange. But yes, just be open to the media. If they say doctors should not be criminally held liable, I disagree. It depends on the facts. And in the Van der Walt case, my personal opinion is he deserved for the parents to have taken him to court, because what he did was not right and was not good. Then the next one that I ask is IM versus the NEC. That case, all I wanted you actually to see there, and it must be a warning to those of you attorneys and having medical legal practices. Don't do a selection of cases, because in that specific case, the attorneys played for time, or they wanted to see first whether there are going to be a case or not. So there was a whole interrelationship between the client and the attorney, but you get the feeling that the attorney didn't want to promise or take the case unless he was sure there's going to be a lot of money, because all of them take it on contingency, and remember, then they can get either 100% of the cost or 25% of the damages awarded. So I just wanted you in that case to see a little bit of according to me, bad lawyering. Then the next one, NEC versus PN, that concerns the payment of a lump sum, the once and for all rule. You cannot actually see that case in isolation. You will have to, at some stage when you work with it, not necessary for the activity, also go and see the DZ case and the Mashinini case. But this is a very, very, very relevant issue now in medical law, whether they have to pay one amount once and for all, or whether the court can say the medical care that the baby who got cerebral palsy need will be provided cost-free in the public sector, or will be paid as and when needed. So you need to take cognizance of that debate, because that the Constitutional Court ruled that you need not pay once and for all, and you need not pay just in money. You can also pay by providing the services. And then the last case that you are going to do, I know you're not busy with that yet. It's a terrible, terrible, terrible case of what a doctor did when he was still specializing, and he went for a disciplinary hearing at the HPCSA. Last time, one of the students in the group complained that there's a lot of quotations in that De Bruin case in Afrikaans. I apologize for that, but that is the best, or actually the only case that I can use to indicate to you the processes at the HPCSA. But the questions that I have asked is not based on the Afrikaans quotes. So you will still be able to get 100%, and you will still be able to answer the questions, even if you do not understand the Afrikaans quotes. But that is a case that you will never forget, because it's really terrible. Okay, that's just a few comments on the activities, and I hope you enjoy it. And remember, you are more than welcome to give comments and say that you do not like the way, or it's too easy, it's like a comprehension test, etc. So you can make comments, but the point is that Bonnie and I hope that through going through every case prescribed for the activities, we teach you something more, which is not necessarily in your theory. Okay, then just a few new developments. We've spoken about this last time as well, that NVM versus Tembisa case. You can watch it. It went to the Constitutional Court. You can watch it on YouTube. The judgment is not out yet. Be open for it. Be alert to see what the judgment is, because it can also change a lot of things in future. Then the other case, the MEC for Health, TM, the TM case. Remember, I told you that is an example of bad lawyering where the wrong things were claimed. In other words, say for example, there's a woman and she's in labor and there's difficulty, the baby doesn't want to come out and they must have an emergency cesarean. But it took too long and it's 2 hours and then only the cesarean, and now the baby suffers from cerebral palsy because the baby didn't get oxygen. Then you should claim specifically, you should claim that the staff was negligent in not monitoring the heart rate of the baby during that time and that time. You cannot claim the hospital or the staff, there was not enough staff. Do you hear what I'm saying? That is too vague. Or there was no theatre available. That is too vague. You must be specific and say during those hours there was clearly an emergency. There was clearly a lack of oxygen for the baby, and therefore there was negligence. They should have made a plan. They should have followed the protocol and observed the baby's heart rate every half an hour. But you cannot claim there were no machines available. It is too vague. So I wanted you in that case of TM to see how wrongly the claims were and what the judgment was, because the judgment was for the MEC. It was in the Supreme Court of Appeal. So if it was dismissed, my feeling is they will go to the Constitutional Court exactly on the same basis as the Tembisa Hospital. Those two, the facts are very closely related. Then last time I've also told you about the voice of the unborn baby, that mothers must now be given the choice whether they want to bury a fetus that spontaneously aborts before 26 weeks. Previously, the law was before 26 weeks, medical waste. After 26 weeks of gestation, a stillbirth and a burial. And that we argued that was unconstitutional, and judgment was given in our favor. And now we await the Constitutional Court, because it's a constitutional matter. The Constitutional Court have to validate that, and that will happen when the Constitutional Court opens again in November. Okay, and then that Mashinini case, that is just the payment, the once and for all, and in a lump sum. So just take note of that case, as well as the next one, the PN case, which went to the Constitutional Court. That all links with the once and for all rule or the payment in a lump sum. This is then now just background. As I say, you will get the slides. So if you want to follow up or ask me questions later, as I've said, you are more than welcome. Okay, so let's come to what we are doing today. Last time I said that you can institute an action on the basis of a breach of contract or DLIC. Now, where does that come from? Just to refresh your minds, those of you who did your LLB a few years ago, or those of you from the medical fraternity who do not know the law that good, South Africa, we have a common law, and the common law is the law that is not written down. So our common law comes from Roman law, Roman Dutch law, and English law. And it came to South Africa via Jan van Riebeeck in 1952, and it became our legal system. And then as time progressed, laws were made, statutes were enacted, and that becomes legislation. But not everything is in a statute, but it's still the law, and that is what we call common law. Now, under the common law, we have the law of obligations. And an obligation gives rise to the right of one party to claim performance from another party who has a duty to act in a certain way. And then under the law of obligations, we have the law of contract and the law of delict. Contract, you have to comply with the requirements of a contract, and when you do not, for example, when you go to hospital, your admission form is a contract between you and the hospital. Or if you go and see a doctor, there is a contract between you and the doctor. A contract need not be in writing, but you must have contractual capacity, meaning you need to be above the age of 18. You must, it must be possible for the contract to take place. And then when there's breach of contract, the damages that you claim must be actual proven damages. In other words, invoices, amounts. You cannot claim for pain and suffering under the breach of a contract. That you do under a delict. So a delict is when there's an act of a person, it is wrongful, it is culpable, and there are damages. Now, all medical practitioners have the obligation to treat the patient with reasonable skill and care. And if they don't, then they are firstly breaking the contract between the patient and the doctor, and they will be guilty of a delict, and you can claim. So that is sort of background. Now, when there's alleged medical negligence, you as the attorney can decide, am I going to sue the doctor or the hospital on the basis of a contract or on the basis of a delict? Sorry, I'm just drinking water. Or on both, because you can do both. As I've said, the majority just go for delict, but you can do both. What are the requirements for a delict? First of all, there must be an act. So someone must have acted, in our scenario, the doctor or the nurse. Wrongfulness is more difficult to define. That depends on the public's opinion, whether they see an action as wrong or not. And why I have highlighted causation, that is the most difficult. There must be causation between what has been done and what is the end result. In other words, if the gynecologist did the scans, interpreted it correctly, told me that the baby is suffering from Down syndrome, give me the choice of an abortion or not, that is how it should be, and that is perfect. But if the doctor interprets the reports wrongly or negligently, in other words, he or she either doesn't know how to interpret it or they miss something, and now tell me that I'm expecting a normal baby and I have the baby, and therefore the baby is now with Down syndrome, then I can institute an action, because there's causation between what the doctor did wrong, negligently, and the end result. And once you've proven causation, you've basically proven your case. Fault is intention or negligence. In medical law, it is rarely intentional, because doctors will not intentionally damage you, but they might do it negligently. And then someone must have suffered damages. I'm just quickly going to refer to a case here, because sometimes the causation is far away from the result. In other words, it is remote from the actual damage. And it's an extremely sad case, and you will get the reference at the end of today's webinar. I've listed a lot of cases, and this is one of them, so you needn't write it down. You will get it. You can follow it up. But it is the case of the Premier of the Western Cape versus Lewis. And it went, this is an appeal case, it went to the Supreme Court of Appeal. Usually when the MEC is listed first, then you should by default, no, it went to the Supreme Court of Appeal because the High Court usually starts with the patient's name versus the NEC. But what happened in this case, and it is really, really, really terrible. This husband and wife had 3 children. They had 3 children and they could not afford another one. And therefore, she went for a sterilization in a public hospital. She thought it was done. Of course, they had intercourse and she fell pregnant again. So there's a 4th baby on the way, which they cannot afford, which they did not plan, and which they actually did not want. So she went back to the hospital and the hospital said, but okay, you have the choice to abort the baby because according to the Choice on Termination of Pregnancy Act, for social and economic reasons is a good enough reason for a lawful abortion, so she can do that. But she and her husband talked to each other and went back to the hospital and said, no, they will not opt for an abortion. It is against their religion. They will have this baby. So they went through the whole pregnancy. Nothing went wrong. But after the birth of the babies, things went completely wrong. Things went completely wrong. And eventually the mother ended up as a vegetable, but the baby was fine. So there was the poor father, 3 little children, now a 4th baby, and the wife in a vegetative state. And then they instituted action to claim damages, but then the High Court said no. The fact that the sterilization was done wrong is too far removed from the end result of the mother. But the Supreme Court of Appeal said no. But for the wrong sterilization, the woman wouldn't have ended up in that vegetative state. And they overruled and they gave in favor of Loots the judgment. Sad, sad, sad case, but you will get the reference and you can read it on your own. But that is just to show the difficulty with causation. Okay, now this is the most important thing that you must remember from this whole course that you're doing is this question in red, because that is the test for medical negligence. How would a reasonable, competent practitioner, it can be a GP or a specialist or a nurse or an anaesthetist or a physiotherapist in that branch of medicine have acted in a similar situation? The full definition is in your study material. I just summarized it here. So what does it mean? For example, if the specialist, the surgeon, is busy with an operation removing an appendix, and for some or other reason the scalpel just perforates an artery, that can happen to anyone. Remember, doctors are human beings, and that can happen. But what did he do afterwards? Did he repair it? Did he assist? Did he help? And then we go further. In other words, what will the reasonable surgeon have done? Will they have just left the artery open so that the person will be bleeding to death? Or will they repair it? They will check. They will check what another surgeon would have done in the similar circumstances. Now that is very difficult. How do you prove that? How do you prove that the doctor or the nurse or the physiotherapist or the anaesthetist acted reasonably? And this is where the problem comes in medical negligence cases. You will need an expert. You will need another person in the same profession to come to court and to testify that the person who is accused of the negligence did not act reasonably. And this is a huge problem, and this is where the costs also come in medical negligence cases. Sorry, I'm just drinking water. If you take a case on contingency, then your company or your practice need to be strong enough to carry the financial burden until the end of the case when the damages are awarded. In other words, you will have to pay the experts. And then when the damages are awarded, then you get your money back, etc. But it is expensive. You have to pay an expert witness. They will not do it for free, and they are not cheap. For that case of the fetuses, the burial of the fetuses, we used an expert, and just for a 6-page expert opinion, we had to pay 63,000 Rand. So in other words, experts are not cheap, and they are difficult to find, but you cannot win or have a case without an expert. It is impossible. You cannot prove medical negligence without an expert coming to testify and say that the doctor who's accused did not act according to protocol or according to what is expected of him or her. That is why I want you to read as many cases as possible, because you will see the roles of the experts. Okay, where can you find an expert? It's always a good thing to maybe start at a university and get the professor of gynecology or the professor of surgery or the professor in psychiatry. They are usually willing to act as expert witnesses, and they are usually not hired guns, which means they will look objectively at the facts and give an opinion. A hired gun is when you get a doctor to come and say what you want him or her to say. And that is not ethical and not correct. Remember, the role of the expert is to help the judge, because the judge have no medical background. So the expert must come and explain the science so that the judge can decide. But remember, medical negligence cases is not to be proven scientifically. They still stay legal matters that have to be proven on legal terms. But in order to understand what happened, you need an expert, especially during labor. When was the damage done to the fetus? Was it in utero while the baby was still in the uterus? Was it while the birth process took place, or was it just after the birth? These things are extremely important because that determines where the blame should be. Did it happen in utero, in the uterus, for some or other unexpected reason? Maybe the mother fell, or maybe the mother consumed something that was bad to the baby. Did it happen during that period that it was in the mother's uterus? Or did it happen during the birth process? They used forceps, or they used a suction mechanism to get the baby out, and in that process they hurt the baby. Or was the baby perfect and normal outside, but then had not being taken care of, and then something happened? Because these things are extremely important to see where exactly the negligence came in, and for that you will always need an expert. Also be careful, it must be an expert in that field. In other words, if it's a labor issue where a baby was born, you will need a specialist in gynecology and obstetrics. because a general gynecologist just looked at the sexual health of women and men, but doesn't necessarily deliver babies. So it's a gynecologist who's also an obstetrics. Those are the people that deliver babies. So you also cannot sue a, 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 a a surgeon for something that the anaesthetist did wrong, or get an anaesthetist to testify on what the surgeon do. You need to have the expert in the field of where the things went wrong. Then you can go to the website of SAMLA, and it's an abbreviation of South African Medico-Legal Association. It's nice to go to their website, even if you do not become a member. They also have case discussions there. They, from time to time, have short courses, or they have webinars where they get specialists to talk about. And because I cannot cover all possible cases, it's always nice to go to their website and see a summary that advocates or judges have made about certain cases. And they have a list of people who are prepared or who are experts in the field of being an expert witness. So that is a way where you can find an expert witness. What is the crux of an expert witness? If you read the case of Michael versus Linksfield Park Clinic, you will see that they say there, how does a judge decide? Remember now, the judge is sitting there. Of course, the doctor has experts, and of course, the patient has experts. And the judge in between with no medical knowledge, who does he believe? Which one of the two teams at the end of the day will help the judge coming to a conclusion? And in that case of Linksfield Park, it is said there that they follow the expert with the logical reasoning. In other words, the judges are not impressed with necessarily all your qualifications. They are more impressed if your reasoning as an expert. Remember, an expert is allowed to give an opinion. A factual witness cannot give an opinion, but an expert usually must give an opinion. In other words, the judge will say, Dr. Pistorius, in your opinion, was the damage done to the baby during labor or after labor? And then that doctor has the authority to say during labor, but then he must explain why he say that, and that must be logic. It must be a logical flow of his reasoning from a medical point of view, and then the judge will accept it or not. And when you read through a lot of cases, you will see that judges make comments, and some judges do not like some experts. And the thing is, expert judges also drink tea together, and they also sit in a tea room, and they also skinner. So they also talk about advocates and attorneys and expert witnesses. And if an expert loses credibility, the judge will always remember it, they will talk about it, and when that same expert appears in another case, they will not listen or take cognizance of that expert. So it's very important that you find an expert of high standing, of credibility, a person that can look at the facts, be objective, and creates a good impression. And that's why I've noted the case of Opelt there. It was a case that eventually ended up in the Constitutional Court. And as I've said many times, if there's nothing on Netflix to watch tomorrow night or Saturday or Sunday, read the case, because it is interesting. It is extremely interesting. It's like a movie playing off in front of you. And what was very interesting in that case, there's a majority judgment and a minority judgment, and there's two teams of experts, and the court favored one And I can, up to today, do not understand why they favored him, because I got the impression of he's very arrogant, etc. But it is good to read that case to see the reasoning of the court. And then at the end of the day, I mean, everyone is entitled to an opinion, and I do not say my opinion is correct. Not at all. The same with that case of the mother's autonomy versus the best interest of the baby. I specifically asked the question that you should say, are you with the majority or the minority? Because I want you to think, if you were the judge, with what side will you go and why? Just for your own fun. I mean, the judgment has been given. We cannot change anything. We can write academically and say with greatest respect, maybe the judge should have considered other things, etc. But it is very good reading and a very good indication of the reasoning of the courts. And then I've said right at the beginning that if you can get hold of the book Van der Heever, which is very sad, he was a senior counsel in the Western Cape. He unfortunately died 2 or 3 years ago, but he and Lawrenson wrote the book Expert Evidence in Clinical Negligence. You cannot have or take on an alleged medical negligence case without that book, because that book tells you step by step what to do. It tells you how to get hold of documents, public sector, private sector. It tells you how to negotiate with an expert witness. It explains to you the agreement between you and the expert witness. It explains in detail what is expected of an expert witness. How should you pay an expert witness? You cannot have a successful case without consulting that book. It is highly, highly, highly recommendable. Okay, so let's go back. Medical negligence. How do you prove it? Remember now, I have said that you must first of all prove all the elements of a delict. If you, let's assume you're going to claim on the basis of a delict, but it's on a balance of probabilities. Remember, that is the difference between a civil action and a criminal action. Van der Walt, criminal action had to be proved beyond reasonable doubt. But medical negligence, civil action, on a balance of probabilities. It must just be probable. Then you've proven your case. But you have to prove someone acted, there was negligence, and someone suffered damages. And the damages that you suffered is causally linked to the act. So if a client comes and sits in front of you and tells a story of what happened, in your mind, you must check, was there an act? Was it wrongful? Was there fault? And did someone suffer damages? And can the damages be proven? And is there a causal link? And I am busy now with research to write an article on cerebral palsy through the court cases. It is extremely difficult to prove causality. If you start reading about 20 cases, you will see that every time other things come into play. But this is the most difficult to prove the causation. Remember, I also said right at the beginning of the first webinar, a bad outcome in a hospital or an operation or treatment is not necessarily negligence. So a bad outcome after an operation is not per se negligence. Negligence have to be proved. How do you prove it? By first of all complying with the requirements of a delict. Then the test, did the person act like a reasonable doctor? How do you prove that? You need an expert to go to court and say this guy did not act like a reasonable person in this circumstances or not. But causality is very, very important. Now, what are the factors influencing medical negligence? The first one is the imperitiae culpae al ad numerator rule. Very difficult Latin. What it means is when you act out of your scope of speciality and you mess up. What then? For example, a general practitioner does a breast enlargement and something goes wrong. Then they're going to measure him against a plastic surgeon and not against a GP. In other words, if you act out of your scope of expertise, you're going to be measured against the higher standard. You're going to be measured against the higher standard to decide whether you were negligent or not. The example I give there is Frick versus Scholes. You can see it's two surnames, so it happened in the private sector, but it was a doctor who performed a gastroscopy and a colonoscopy. She did all the courses, but she was never accepted as a surgeon. She's not on the register of surgeons. In other words, she did not write a final exam or whatever, so she was not a surgeon. But her business cards indicated that she was a surgeon. And she did those colonoscopy, those operations that's supposed to be done by a surgeon, but she was just a general practitioner, and then things went terribly wrong. And then she was measured against a reasonable surgeon. And the reasonable surgeon would have acted differently from what she did, and she was guilty of negligence. So that whole Latin phrase just means it is a person acting outside the scope of his or her speciality. Then there's another very interesting thing that can influence negligence, and that is the locality rule. The locality rule. And the locality rule basically say that should you measure the people, whether they are in Sandton or whether they are in Lephalale or Soshanguve, do you measure the people the same way? Can you expect the same thing from a doctor performing an operation in Sandton and a doctor operating in a hospital in Tembisa? I don't know what you feel, but there are two schools of thought. The one school say doctors get the same training and therefore they must act the same irrespective of the circumstances. And others say, no, you have to take the circumstances into consideration. There is no clarity yet in our legal system. It has not necessarily been pleaded as such, naming it the locality rule, but it is something which I think you should remember. I just mentioned there a case that you can look at. It happened, it's a case of the Supreme Court of Appeal, S versus Tembani. So you can see that it is a criminal case, the state versus Tembani. But what happens there is that this guy shot his girlfriend. So he actually wanted to kill her, but she didn't die. So she went to hospital, and because of negligence in the hospital, she died. Because of septicemia, she died. And then he claimed a novus actus interveniens. He said there was, he cannot be guilty of murder because she died of septicemia. But the court said no, and they overruled and they found him guilty because he actually wanted to kill her. It is just bad that she got septicemia in Tembisa. There on the slide you will see there's an article that I refer you to. It is published in the South African Public Law Journal. It is open access, so you might be able to find it if you are interested in this topic. And then the two different views you will get in Van Wyk versus Lewis, and there's a link for that case on your website. But yeah, I want you to really think about this. If a person has to perform an emergency cesarean section in Milpark Clinic, and one has to do that in Charlotte Maxeke, can you expect the same? According to me, in our South African scenario, I am of, once again, opinion. There's no right, no wrong. It's my opinion. I think the locality rule has a role to play, especially because our public sector is in such shambles, and our private sector with medical aids is a little bit better, although also not perfect. But I think locality definitely plays a role, but then maybe someone can do a master's degree or something on it, but there's no specific clarity, and it is never specifically pleaded in cases. So just take note of something like the locality rule. Then just take note that in medical law, negligence is negligence. So we do not speak of gross negligence. Once there's negligence, there's negligence. How bad the negligence was might just have a bearing on the sentence or the punishment. For example, let's go back to Van der Walt, the gynecologist, the criminal case. He was negligent. He should have gone to the hospital. The moment he was advised by the sister that the patient was still bleeding excessively, he didn't go. So that is negligence. But then how he reacted and what he did, all those bad things, one gets the feeling it was gross negligence, but it only becomes applicable during sentence or punishment. So you need not speak about gross negligence. Medical negligence is negligence, and that's fine. Then contributory negligence. Last time I briefly spoke about that. That is the case of Dube versus Administrator Transvaal. You can see it's quite an old case. It was where he had an elbow fracture and his arm was put in plaster. And they said to him, if something's not right, he must come back. But the plaster was too tight. He didn't realize it was wrong. After a few days, he couldn't stand the pain anymore, then went back and they had to amputate the arm. And then the argument was he contributed to the outcome because he should have gone to the hospital earlier, but the court said no, he was not supposed to know how it should feel before he went back, and it was overruled. So take note of contributory negligence. There's also the case of, if I remember correctly, there's a case where the doctor and the hospital, and one was 60% responsible and one was 40%. So take note of that, apportionment of damages, contributory negligence, when you come across it, that there exists something like that. Then errors of judgment. For example, if you go to a doctor and the doctor say he thinks that the lump in your breast is cancer, but he's not sure, and you go to an oncologist and they do test and they say, no, it is not cancer, and you go on with your life, and 2 weeks later, maybe if you're in another situation and they find out that you actually have cancer, so it was a misjudgment or an error of judgment, none of that will be per se negligence. It depends on whether the ordinary doctor or ordinary reasonable oncologist would have made the same mistake. So the same test will apply of the reasonable doctor. Would he or she have made the same mistake or not? Okay, so Criminal cases, I've said there's not a lot of criminal cases. We've spoken about the Van der Walt case. You did it for a activity, so you know about that, and you know about the Constitutional Court case. You can also see the case of S versus Kramer. That is where the anaesthetist was involved. And remember that when it is a criminal case, then it must be proven beyond reasonable doubt. This is also maybe a nice area of extra research. Should we go the criminal case route or not? Should it be allowed or not? It needs a little bit of more investigation. But now, and this is just for interest, there was a case of Frederickson, and it went to the Free State High Court. And what I want to show you here is never to accept just an act. Remember, an act has regulations, and the regulations become sort of part of the act. What happened in this case is this guy, I can't remember now whether he was, I think he came from Austria, somewhere there, or Sweden. Bad guy, many other things. He had weapons without licenses, etc. But what he did is he invited women from Lesotho into his house. Then he gave them a lot of alcohol and a lot of money. And then while they were sort of unconscious, he circumcised them. And then he took their clitorises and put it in little boxes in his freezer. And then he was caught out, and he went, because that is a crime, so he went to the criminal court, and he was charged with a lot of crimes, as I said, for having weapons and a lot of things. But he was also charged with having human tissue according to the National Health Act in his possession. But then there was an objection by his defense that said these charges could not stand because of the principle, and I don't know who of you remember this from criminal law, nulla punna sine lege. You cannot punish someone if the law doesn't prescribe a punishment. Now, the National Health Act does not in Chapter 8 prescribe the punishment for a person having human tissue in his or her possession. And the judge accepted that argument, and the charges based on the National Health Act was withdrawn. And that was completely wrong, because there are regulations of human biological material that goes with the National Health Act, and in the regulations there are the transgressions and the penalty clauses. But neither the judge nor the advocates consulted the regulations, and therefore that person, those charges were withdrawn. And it is a disaster. It should never ever happen. So please remember, when you work with the National Health Act or the Children's Act or the Choice on Termination of Pregnancy Act or the Sterilization Act, you must always do a search to see whether there are regulations in terms of the Act and what does the regulations say. Because in this specific case, something went completely wrong, and the guy wasn't charged because they said he couldn't be charged because there was no statutory prescription on not having human tissue in your possession, but all of that was in the regulations. So always remember to check the regulations. And you can go even further. If it is someone registered at the HPCSA, you must also look at their prescriptions, their ethical codes, in order to build your case. Okay, let's come back to causation. There's factual causation, and that is what I call the but-for test. When you hear about the but-for test, remember it refers to factual causation. as I've said, but for the
Put the last one.
putting on the plaster too tight, he would not have lost his arm.
There's some very hectic cases, hey?
Caroline, can you just mute your microphone? Caroline Serifusa. Yes, thank you. Okay, so factual causation is the but for test. But for the plaster being too stiff, the blood flow wasn't in the arm, he lost his arm. So you ask that, but for the gynecologist not looking at the test, a baby is born with Down syndrome. But for the surgeon cutting open an artery, the person would not have bled to death. So that is factual causation. What are the facts? And the detail you can see in that case, Lee versus Minister of Correctional Services. Unfortunately, a thick and difficult case. It ended up in the Constitutional Court, and it concerns an inmate who contracted tuberculosis. But there you will see how the court argues about causation. And then I just give you another more recent one where you can also see how they argue about causation. Okay, who has the onus of proof? Of course, the onus of proof is on the plaintiff or the patient, and that person have to prove it on a balance of probabilities, and a criminal one beyond reasonable doubt. A balance of probabilities is the same as a preponderance of possibilities. It's just the same words used differently. Then you would have seen in your theory, or you might have heard about res ipsa loquitur. The facts speaks for itself. For example, in that Van Wyk versus Lewis case, it is 1924 case, but it still stands, where a swab was left in the abdomen of the patient. The fact that the swab was left in the abdomen and it became septic is not per se negligence. It depends on the facts. And if you read Van Wyk versus Lewis, you will see that the swab was left because they had to close the abdomen quickly, otherwise the patient would have died. And therefore they could not count the swabs. One was left, became septic, she needed another operation. But you cannot then sue for negligence because the circumstances was such that they had to close her very quickly. Now, res ipsa loquitur, the fact speaks for itself, does not stand in South African medical law unless it's specifically proven. In other words, let's say your niece calls you tonight and say, hey, you must help. Her mother went to hospital. She's got extreme pain. She went for x-rays and they see there's scissors in her abdomen. Don't jump up and down and say, yes, we're going to sue the hospital, we're going to sue the doctor because this is blatant negligence. We're going to claim 32 million rand. You cannot. It depends on the circumstances. The fact that the scissors is in the abdomen, go and look at the facts. Why was it there? And then only can you come to the conclusion that it was negligence or not. If you want to see a case of blatant fact speaks for itself, then you can go and read N versus MEC for Health Gauteng, the reference that I'm given there. What happened there is this woman gave birth. Difficulty, she had to get a cesarean procedure. The baby was taken out, but in this whole process, the baby's arm was cut. The baby was taken to the neonatal department and the mother back to the maternity ward. The mother became septic, so she needed extra help. 3 days later, she was in such a state that she could go down to see her baby. And you will not believe it that for 3 days, not one of the staff members attended to the baby. The wound, the cut on the arm were not looked after. The baby wasn't fed. Absolutely nothing happened. So there the judge said, the facts absolutely speaks for itself. There was negligence towards the mother. There was negligence towards the baby. The facts are so clear that it needn't be proven like in the difficulty of all the other cases. So in that case, you will see where res ipsa loquitur was definitely applied, because it's a terrible case, nice case to read, nice case to take notice of. Then you should also take notice of vicarious liability. Vicarious liability is where the employer is responsible for the actions of the employee. And why do I say this is important? Remember, at the beginning, I said that everyone in the public sector, all the doctors, all the nurses, physiotherapists, speech therapists, anaesthetists, all of them in the public sector are employees. And that is why you never sue them, but you sue the MEC or the Premier, because our health is divided between the 9 provinces. But very important, remember, in the private sector, the doctors are never employees. They are always independent contractors. The nurses, that will depend. Some hospitals will have nurses in their employment permanently working for them, and other nurses will be provided as and when necessary through a labor broker. So it is very important to understand with what are you dealing with, an employer, employee, etc. And there I've just listed an article that I've written, because doctors cannot work forever. So they sometimes go on holiday, they sometimes go to conferences, and then they get a locum to stand in and work for them. But how is the locum appointed? Is the locum an employee, or is the locum an independent contractor? Because that will also depend on how you will claim or not. So take note of that. Whenever you have a case and it was a locum, you can send me an email, or remember that you've heard it somewhere, and you must determine whether the locum was an employee or an independent contractor. Now, this case, S versus Kramer, I've noted it on the previous page, a surgeon and an anaesthetist. This is very interesting, and this is also something you must remember, because it makes it difficult in South Africa. In South Africa, we do not have a principle of a captain of the ship. In other words, let's take a scenario. You go to hospital, you need a neck operation. So first of all, you will see your GP. Your GP will say, okay, he thinks there's something terribly wrong, and he will refer you to the orthopedic surgeon. The orthopedic surgeon will say, okay, you need an operation. But because it's so close to your spinal cord, a neurosurgeon must be there as well. Of course, there need to be an anaesthetist, and there need to be nursing staff in the operating theatre. Now, the question is, who of these people, which one is in charge? Who is the responsible person? If something goes wrong, who must go and speak to the family? Who must get informed consent? So it's extremely difficult. In England, in Britain, they have a doctrine called the captain of the ship. And they say that the surgeon is always in charge. But that does not apply to South Africa.
In South Africa, because the anaesthetist is an independent contractor, the surgeon is an independent contractor, the neurosurgeon or the neurologist is an independent contractor, and they are not responsible for each other. And it creates a difficulty, because if something goes wrong, where do you start? So you basically have to sue all of them, and each one have to come and say why they should not be sued, because otherwise you don't know. And it is really difficult, and you must remember this when you go to hospital practically, because who at the end of the day must come out of the operating theatre and speak to the family and say everything went well or something went wrong? We don't know, because they are all independent. The one is not responsible for the other one. So let's look at this scenario. Dr. Y has been working for a partnership of doctors for the last 2 years. He is paid per hour, and they do subtract pay as you earn, which is tax. They do not have a formal contract. But one day he makes a misdiagnosis. In doing his ordinary work, he makes a misdiagnosis and the patient dies, and then there's a medical negligence case, and Dr. Y is held responsible. But he doesn't have medical insurance. Remember, each doctor has insurance that if something goes wrong, the doctor will not pay from his or her pocket. The insurance company will pay. But what now in this scenario? What do you think happened there? Okay, let's analyze it quickly. He's working for a partnership. Okay, so those of you can remember from your mercantile law, a partnership is not a legal entity. So all the partners stays as if natural people, and they are responsible for all the profits and the loss of the partnership. Okay, so that's the first thing. He worked for a partnership. He worked there for 2 years. He were paid per hour, and they subtracted pay as you earn. In other words, what does this scenario create for us? That he was an employee. Do you see that? Because he was paid fixedly. He already worked for 2 years, and they subtracted pay as you earn. All those things indicate that he was an employee of the partnership. Okay. Now, in his work, in his ordinary work, he makes a misdiagnosis and the patient dies. Who should be responsible? Dr. Y, yes, because he's the doctor. If it is proved that he was negligent, then he in his personal capacity. But can you see, what would it help? If the damages or the claim is for 20 million, Dr. Y will definitely not have the money to pay that. And because of this scenario, what comes into play? Vicarious liability. The conclusion can be drawn: he was an employee of the partnership. He acted in his scope of employment. So therefore, the partnership becomes responsible for the claim, especially because he doesn't have insurance, which is an oversight. The partnership should have made sure that he has insurance, but he doesn't. So in other words, what will happen? If I was the patient, I will sue Dr. Y, I will sue the partnership, I will sue each and every partner of the partnership for the damages that was suffered. Okay, so I hope you with me. Remember, afterwards we can have conversations and talk. I just want to finish so that those of you wanting to have a long weekend can go. So I'm getting there. I'm nearly done. Okay, so what can be possible examples of medical negligence? A misdiagnosis, where a person do a careless examination. People, the downside of this is that doctors are now so scared of attorneys or lawyers that they over-diagnose. Sometimes you will go and you will say your hand hurts, and they will immediately send you for x-rays, only to see that it's a minor thing or whatever. And that is what is called defensive medicine. In other words, they over-diagnose because they are scared of making a misdiagnosis. And that is why we pay such exorbitant fees for medical aid cover, is because they are so scared of being sued that they over-diagnose. Errors of judgment, that can happen to anyone. You can read a scan and not pick up Down syndrome. Remember, the question will be asked, will the reasonable gynecologist make the same mistake or not? Of course, not getting informed consent. That is the biggest and the biggest problem in medical negligence, not getting informed consent, because there you are protected by the Constitution, your right to self-determination and autonomy. So if a doctor treats you or does something to you without your consent, it is basically assault. Failure to refer. Remember, you have, if you do not have the expertise, if a doctor starts the treatment, he must finishes it. Unless he doesn't have the skills, then he must refer you to a person who can do it. They cannot just abandon you. Remember that I said about abortion. If you are not willing to do an abortion because of religion or cultural objections, you cannot just leave the girl child. You must refer her to someone who will then help her, because she can have a legal abortion. Failure to follow up after an operation. This is the biggest, the biggest cause of medical negligence cases. A lot of hysterectomies end up like this. The women have to go for a hysterectomy. The gynecologist goes, removes the uterus. She goes back to the ordinary ward, starts bleeding. The nurses call the doctor. The doctor doesn't come, just give a prescription over the phone. The woman still bleeds. The doctor shows up late. Negligence, septicemia, maybe death. I say again, any doctor can make a mistake. Any operation can go wrong. But what they do once things go wrong, that is where the test comes in. What will a reasonable person do in that circumstances? Was it done? No, then there's negligence. Was it done right? Although the outcome is bad, then there's no negligence. Okay, and then obviously things that can go wrong in surgery is where you operate on the wrong leg, or you do the wrong procedure, and you won't believe it. You think this doesn't happen. It does. It does, that people go and they operate on a wrong leg or things like that. So it happens. What are the areas where it's most commonly happens, medical negligence? Is obstetrics and gynecology. They prescribe the wrong medicine, or they don't ask you whether you're allergic, for example, for penicillin. They use faulty equipment, or they use, if they have to get the baby out, the suction equipment is not working. Radiology is where you get burned when you go for x-rays. Blood transfusions, where you're given the wrong blood. And remember, Jehovah's Witnesses, if they insist no blood, then you stick to it, except when it's children. The Children's Act in section 29 have overruled it. If it's in the best interest of the child, even if the parents refuse, the blood transfusion will be done to the child. And then a surgery and the locus classicus, in other words, the best known case for medical negligence is Castell versus de Greef. There's also on your website a link to that case, and that case in detail also explains informed consent. So it's worthwhile looking at that case. Okay, now practically, how do you approach a medical negligence case? First of all, gather all the facts from the plaintiff or the person complaining. Now here, a big word of warning. People remember selectively. Selectively, so they do not remember everything, and every person remembers the things differently. If there's a car accident and you ask 4 bystanders, one will say the car was red, one will say it was blue, one will say it was a male driver, the other one will say it's a female driver, and then there's reality. So you have to listen to what the person say, with keeping in your mind that they remember selectively. Some attorneys, what they do is they ask the patient to write everything down from the very beginning. In other words, let's say a child went to hospital and is now paralyzed. Then they will ask the parents to write down from the child's birth. Was it an active child? Was it an healthy child? Then what happened? Why did the person end up in hospital? What happened in hospital? As much detail as possible. So you can either ask the plaintiff to give it to you in written form, or you can listen and record it or just listen. But keep in mind that people remember selectively, and keep in mind that a person tends to lie or to give a different view. I can still remember when I started as an advocate and we had to interview mostly criminal cases below the court in the holding cells. And you will speak to the person and they will always tell you they only had 1 beer, just 1 beer. They are there for drunken driving, made a huge collision, but they only had 1 beer, which is a blatant lie, because no person just have 1 beer and then makes a huge accident. So evaluate your client, listen to what the person say, write down the facts, ask as many questions as possible, get as many facts as possible. And then once the person have said everything and have spoken about everything that he or she can remember, ask the client, what does he or she want? Do they want answers? In other words, they just want to know what went wrong. They want answers. My husband went in healthy, he died. He's the breadwinner. I have now no one to look after me. Why did my husband die? I want answers. Or I want revenge. I'm angry because the doctor messed up my view or whatever, so I want revenge. Or I want money to sustain me because my husband is now dead. So he was the breadwinner. He was looking after me. He died in the hospital because of the negligence of the doctor. So I want money to be supported. Ask your client what they want, because that will give you an indication what is going on in this person's mind. If they say, I want revenge, I am so fed up with this plastic surgeon that made a mess of my breasts, I want to sue him and I want to ruin his reputation, etc., then you get the feeling of your patient. Remember, you must still decide whether there's a case or not. Okay, but let's say your patient have now indicated to you they want answers, they want damages to be paid out because they are losing money now. They've told you the whole story. Now you get the hospital reports. And in that book of Van der Heever, I explained to you how you do that, how you ask. A hospital will never give you the originals, but they are compelled to give you photocopies of the originals, and you will have to pay for it. It is more difficult to get it in the public sector, but you have to insist and you have to get it eventually. But as I say, you will have to pay an amount because they will give you photocopies. And make sure they give you everything, because sometimes they might just leave one page out. Or what happened in a case that I'm aware of, they photocopied only the one side of the page and not the back side. And there was information on the back side as well. But anyway, get the reports, as many as you can. Now you look at the hospital reports. And remember, now you have your story of your plaintiff, and then compare it. Compare it and see whether a story unfolds in front of you. Because you will immediately see either the one is lying or this one is fantasizing or whatever. But if you've got all the facts on the table, then you will see a story unfolding in front of you. And then you identify the law applicable. And that is where you now check. Am I going to take on this hospital on the basis of a contract? Is it the hospital that I'm angry? Is it against a doctor? So am I going to do it on contract or delict? Contract, if I do not want to claim pain and suffering. Contract and delict if I want to claim pain and suffering. But with the facts on your table, check. Can you prove the requirements? Act, wrongfulness, causation, damages, and the requirements of a contract. So you play in your mind with your legal knowledge and the facts, and you see, will you be able to prove all that elements? If the answer is more or less yes, although causation might be a little bit difficult, you take all that information and you find an expert and you give that expert all the information you have, the version of the plaintiff, plus all the hospital reports. You give it to the expert and you ask for an opinion. So the expert will now look through the glasses of medicine, and he will look at the story. Is the story of the patient possible? Is the hospital records confirming it or not? And then the expert will give you an opinion and say, if I look at the hospital records and I read what the patients say, something here is wrong. They did not monitor the heart rate regular enough. They should have. So the expert will indicate to you something went wrong. There's definitely the possibility for a case. This is my opinion. And then on the basis of that, you start instituting action, you issue summons, and the legal process starts. Then I've just added there, remember that the court rules have changed and that you basically now should go for mediation first and indicate to the court that mediation was not successful. You must act according to the rule. Mediation, for me, is a good thing because most of the time, the patient in front of you, most of the time just want answers. I want answers. What went wrong? For example, I was involved in a case of a young man and a young woman. They had 2 young children. She went for a sterilization, a laparoscopy, where they just bind off that she do not produce eggs. It's a minor operation. You go through what is a nalki in English? On your tummy, that hole. They go through there, they blow it up, and they do the sterilization. It's supposed to take about 45 minutes. And the next moment they came to him and they said she died. And she wasn't supposed to be cut open. It was a laparoscopic, so it's air that blows in, and then they work through the vagina, and there was no need to cut. But when he saw her body, she was cut open, and he wanted answers. He wanted answers because he took his wife for a 45-minute procedure, and she died. She hasn't even told her parents she's going to hospital. It was such a simple procedure. So answers. Most of the time they want answers. Most of the time in plastic surgery, they want revenge. When it's children, they want closure. So if you have mediation, you get all the parties around the table, and the husband can look the doctor in the eye and say, tell me, what did you do with my wife? What went wrong? So they can talk to each other. And remember, mediation is not the end. If you're not satisfied with the mediation, you can still go to court and go through litigation. Another way is, of course, if something goes wrong, you can report it at the HPCSA, which will do an independent inquiry. And if the HPCSA determines that there was unprofessional conduct, that is a good indication for you that you might be successful in a civil action. I'll come back to this when we discuss the HPCSA. This is just a new book, The Quantum of Damages, just for you when you prepare a case to more or less determine what will be the damages that you could claim in the case. So that's just a book. So now to end, I've been speaking and I think some of you are now terribly tired of my voice. I know some of you are on your way for a long weekend and you've indicated to me you are going to listen to me on your telephones. I apologize to your family who had to listen to my voice, which is so boring and my English is so bad, but I'm nearing the end. So the last few slides, I have compiled cases to make certain points. Now, this first one, bad lawyering and medical negligence. It is 4 cases, but it's the same poor woman with her child. Lushaba, it started in the High Court. It went further, it ended up in the Constitutional Court. It is terribly sad, but it is a very good indication of how the state prosecutor, people acting for the state, the lawyers acting for the state, messed up big time. It is really disgusting to read the case of how that was messed up, and the poor woman had to go through all these years. I think the case, when did it start? 2014. It started way in 2012. In 2016, the Constitutional Court gave judgment, and it's not done yet. So it's nearly 10 years. But interesting, good reading, really worthwhile going through the Lushaba cases. It's 4 of them interconnected. Then if you want to have cases where you see specifically expert evidence, where there's contradictory expert evidence, or how the court make comments about expert witnesses, etc., then you can read any of those cases. I try to get them as recent as possible, so you will see 2016, 2018, 2020. I think there's more. I try to get updated with everything, but it's not always possible. If you want to go and read more about causation, where causation have been discussed in detail, you can read those cases. And then res ipsa loquitur, where it was not applied. Remember, res ipsa loquitur, the fact speaks for itself. When you read those cases, you are going to think, but the fact speaks for itself. But read the reasoning of the court, because in none of those cases did they accept that the facts speaks for itself. And you will see that the Buthelezi and the Goliath cases are Supreme Court of Appeal cases. So very important to take note of them. If you want to see a case only based on a contract, I touched on this in the first webinar, the Administrator Natal versus Edward. See, it's quite an old case, but she had a sterilization but fell pregnant again, and they sued on the basis of contract, and therefore they could only sue the actual damages and not for pain and suffering. The remoteness of damage, I spoke about this case, the Loots case, the poor husband with the 3 young children and the newborn baby, and the mother ending up in a vegetative state. Warning of rare risks, you can read that case. Remember to get informed consent. You must tell the patient of all the risks, all the pros, all the cons, all the different treatments, etc. But how far does it go when it is when there are rare risks? You can read that Magetla case. Then where res ipsa loquitur was applied, I spoke about that case of the baby's arm being cut and not being fed for 3 days. A novus actus interveniens, that's where something else happens in between. There's a case. There's cases of misdiagnosis. There's the cases of omission where they did not act when they should have acted. So you can read the cases there. There's contributory negligence, hospital records, records. Remember, the basic rule in medical law is if it's not written down, it did not happen. So if the patient say the nurse did not give me oxygen, and it is not on the records that she gave her oxygen, then it's accepted she did not. And unfortunately, one has to lecture hospital staff, but the importance of records cannot be overemphasized. Then there is a lot of cases in the private sector. So don't think it is just the public sector that messes up. The private sector messes up as well. So you can go through those cases of the private sector. There's some more. If you want to see a mess up of contingency agreement, then you can read that Wim Kreino case. Prescription, there are one case. I'll come back to prescription. It is a topic for the next webinar. And then if you want to see how quantum was discussed, you can look at these cases. And it is 10 minutes before the 2 hours are finished. I thank you so much for listening to me. Yup. I hope I've given you something for thought for today, and I hope you're starting to see the big picture, because you've now heard the first webinar, you've gone through all your theory, you have done, I think, the first 4 activities, so you are now nearly my equals. So we have 1 webinar left where I will just touch on a few other things. But now you are more than welcome to ask me questions, to make comments. You can raise your hand. There you can see me again. You can raise your hands, or you can just start talking. Anyone with a question. It is impossible. There must, okay, there's a hand. I can't unfortunately see your name, so you can just talk. Just unmute yourself. Oh, I see. Sabelo, you are putting up your hand. Speak to me. Can you unmute yourself? I don't think I've not muted everyone. Chelsea Kleinsmith, you can speak to me.
Hi.
Hi, okay, so I can hear you. Yes.
Okay. I just wanted to ask about the procedures of BBLs.
Of what?
Of BBLs, Brazilian butt lifts. It's a part of a surgery. Part of surgeries.
Okay. What do
But
you
it's like-
want to know about that? Remember, I'm
Like-
not a doctor.
Now I'm just asking because it's one of the most dangerous procedures in the world. So I just wanted to know if there was ever a case in South Africa of that procedure.
Not that I know of. No, not that I know of. Who does the procedure? A plastic surgeon.
Yes.
You see, where the difficulty comes in with plastic surgeons is because it's elective. It's not a prescribed medical benefit. It's usually not covered by your medical aid. It's completely your choice. So it is an agreement between you and the plastic surgeon. And if things go wrong, it is usually settled out of court. That's the only thing. That's the only thing. If you go into mercantile law and you go through cases, it is officers for cases, but medical law, I think I now at the moment have about 12 lever arch files full of cases, which is not a lot, but it doesn't mean it doesn't happen, but it's settled out of court because the doctor doesn't want his name in public. So he either pays from his pocket or his insurance. Remember, plastic surgeons, their insurance per month is extremely high. So when something goes wrong, the insurance pay out. That's what I think.
Okay, thank you.
Okay, Sabelo, I see you now. Unmute yourself. You had a question?
Can you hear me, Prof?
I hear you now. Yes.
All right, thank you. In fact, I don't have a question. I've got an apology first. I must profusely apologize.
Yes.
Between being out of province and me being sick and the children being sick, I was unable. So I was going to ask for an indulgence up until Monday to submit the portfolio one. I'm apologizing because I don't know which other avenue that I will
Okay.
get. Yes.
Sabelo, absolutely no problem. Just send Bonnie an email.
Oh, okay.
And do you still have my email address as well? I think it was on the previous one.
I'm not sure, but I can quickly take it because I'm taking notes.
Okay. It is my surname SLA.
Slabart.
Yeah, but you just slab SLABB, and then you stop.
Okay.
And then M for Magda.
Yes.
At.
Yes.
UNISA.
UNISA.
.ac for academic.
.ac.
.za.
.za. So it's lab.m@unisa.ac.za.
Yeah, it is not slab dot. It is just slab M. Take the dot.
There's no dot between
There's
slab
no
and
dot.
M.
Yes,
Okay, all right.
Just slab M. But
Okay.
anyway, send an email to Bonnie.
Okay.
Tell Bonnie you spoke to me, and yes, you can have extension, no problem.
All right. Thank you very much. I appreciate, Prof.
Okay, no problem.
My question, Prof, as I was going through this, the other case, between the two cases where there's wrongful, there's wrongful birth, wrongful pregnancy, and wrongful life.
Yes.
The second case that then seems to suggest that we need to. The High Court obviously has got the right to develop common law.
Yes.
So how do you see that happening? And with the attendant contingencies of people using it because of the economic situation and being wise as a benefit of an afterthought that it will open and the floodgates, so to speak. What will be your view there? That should we then stick to it not being acceptable as part of delict and as part of our law, or not?
Okay, the Constitutional Court have already decided for us.
Yes.
So I mean, what my opinion or your opinion is, we can do nothing about it. But the Constitutional Court said it must go back to the High Court. We're talking now wrongful life, ne?
Yes,
Wrongful
yes, yes.
life. It must go back to the High Court. So it is not contra bonus mores anymore, but it need to be proved. Okay, now what happened in that specific H versus the fetal assessment clinic, the parents could not institute wrongful birth anymore because the child is already 6 years old. So the wrongful birth claim have prescribed. So
Oh,
the only
yes.
recourse they have is wrongful life, because it doesn't prescribe, because it's the child claiming.
Yes,
Okay.
yes, yes.
So these kind of facts must all be taken into consideration when a High Court entertain wrongful life. I don't think it will just open the floodgates and every child will now go and say, I should not have been born, or I don't think so. That was what they were scared in the past. But now the Constitutional Court has said it's allowable in our legal system, but it will depend on the facts.
Oh, okay.
Each
all right.
case must be dependent on the facts. Okay.
Okay, thanks, Prof.
Okay, I'm just quickly answering here, Zara. You ask, are doctors in the public sector employees or independent contractors? Doctors in the public sector always employees. Doctors and nurses and physiotherapists and speech therapists, the whole lot of them in the public sector are employees of the state. But in the private sector, they are independent contractors. Nurses, it will depend. Let's see, was there no civil claim in the Van der Walt case? No, there was no civil claim. They just went for the criminal claim. Reason being, my view, I don't have specific facts, but it was a young woman who died while giving birth. The damages, who suffered damages, she did not support anyone specifically. She was not a breadwinner. Do you hear what I say? What kind of damages can you prove? And she died. She died. So of course the mother has pain and suffering, but as I've said to you, that's not quantifiable. So they couldn't do a civil action, and they decided, but something need to be done about this doctor messing up, and then they went the criminal route. Okay, I see there's another hand, Tembile.
Hi, Prof. Can you hear me?
Yes, I hear you loud and clear.
All right. Prof, you've just mentioned there was no claim in that one, the previous one that we've just dealt with. A scenario where a child, after she dies, after the negligence of, she contracted some disease because she was supposed to be put in a separate ward, but that did not happen, and she had TB, and it led to many complications, and ultimately she died while she was in the hospital. And you say that there's likely, because she was a child, there wouldn't be any claim. I just want some clarity on that, if you may help.
Okay. This is sad to me to say to you. But yeah, what damages will you prove? You see, it is so sad and it is so wrong. And it should actually be reported to the HPCSA. Yeah. But what damages okay, let's say you take the case to court. What damages will you prove?
obviously I wouldn't have accepted that we've had pain. The mother has gone through the pain. This thing has been going on. She's been moving from KZN to Gauteng and all that, going for trying to get a date for this. He's taken there, but ultimately this particular child then is transferred to the specialist. Like if I may make a Donald Gordon and the Gordon in Joburg.
Yes.
And the institute, they say that had he been brought earlier on, something would have been done. They waited. The referring hospital took a long time to bring the child to be attended to with a specialist in Donald Gordon or whatever institute they.
Okay, so in other words, you will get an expert who will say if she got to Donald Gordon earlier, she could have been saved, né? So it will sort of be possible to indicate causation because the expert will testify. But still, what damage? What damage? Is it just the pain of the mother and the father? Because how do you quantify that pain?
Yeah. But
see,
don't you think that one has to be, in terms of negligence, they led us to the loss of our child, one and only child, if I may say.
Yeah. Go and read that Tembali case, ne? Which I let me just grab it here. It's next to me.
Okay.
It's on the slides, and the slides I will ask Bonnie to post the slides. The Mbele versus
How do we
MEC
get
for
access
health.
to the slides?
Sorry?
How do we get access to the slides? Do we go to, is it under reading material or?
I will ask Bonnie to send out an announcement where it is. It will either be under announcements or extra reading.
Okay, maybe it may be that even the webinar one slides, I haven't laid my hands on them. I don't know what am I missing. I've got all other information.
Okay, well, no problem. Send me an email and I will send it to you.
All right then. All right.
No problem. Did
so
you get
say that case?
If you read that case,
Tembali.
Tembali. Mbele. Sorry, Mbele. Mbele. If you can prove, for example, that the parents ended up in a psychiatric institution because of the loss, and then you start to get damages, claims, being hospitalized, the pills that they need. But if they just feel sad, you can try, but I don't think any attorney will take the case because there was no damages. What you can do is refer it to the HPCSA. Refer it to the HPCSA so that they can investigate and see what happened there.
All right.
It is terrible. I'm sorry to tell you this, but this is the truth. But it feels wrong. It feels wrong. But if you can go and read that case, it will give some clarity.
All right. Thank you, Prof. I'll certainly do. Thanks very much. For your
okay. Let's just see. In the Van der Walt case, what about the child that was born because nothing is said in the case that she died? So basically, she was denied the right to parental care, love and affection of the mother. Yes. She, as far as I also know, my brain is spinning now. Yes, the child lives, but no one has a right. Where will you sue the right to parental care, love and affection? What right? Okay, the best interest of the child, but what will you claim? It will be impossible. I won't go there. Is the situation of a child's death perhaps better suited to a criminal claim? Try it. It hasn't been. That's why I say this Van der Walt is the first time. It's the first time that we have a judgment, a process you have heard in the news of that young, I think it's a Indian child that went for a minor operation and died, and that anesthetist, and I can't remember who was the specialist, what kind of specialist. They are now being criminally charged, and I think one of them died before the case actually went to court. So yes, you can. You can sue them criminally. It just doesn't happen every day. I see there's another hand.
Yes, Prof, can you hear
Yes.
me?
Yes, I can.
I am on the Health Professions Council
Yes.
on a tribunal, and I think maybe it is wise for us to just understand what they're doing. The council is going to look at the medical practitioner and what they are doing. And if there is any wrongdoing that they find, then it can go to the civil claim. But to answer the other, the speaker who spoke before me, the council, you report a misconduct of a professional, and they will look into that, and they may say the doctor must pay or be suspended or whatever, but the damages will be claimed at a civil court. So we have two processes that can run parallel, and you can go onto the Health Professions Council and prove that there was negligence, but the criminal case can go on at the same time.
Excellent. So actually in our next webinar, we go into a little bit more of the HPCSA, but excellent. Yes, you can report a doctor, and remember the ode alterum partem, the doctor will be given a chance to say his or her side of the story, but the HPCSA will do an investigation and have a disciplinary hearing and come to a conclusion. You as patient will get nothing from that in the form of money or whatever.
Yes, correct.
Yes. But if the HPCSA finds the doctor guilty of unprofessional conduct, it's a good indication to you that you may pursue a civil action or not. But it's completely independent processes. Yes.
Absolutely. And we see a lot of doctors trying to go through the civil action before they go to the health professions. It really doesn't matter. Even if you're not found guilty in the civil action, if you are guilty of unprofessional conduct on the HPCSA side, it will go on that way. So it really doesn't help to choose.
Yes, excellent. Okay, anyone else? Anyone else? Okay, remember you are more than welcome to email me anytime. I will try and help and answer as far as I can. Otherwise, ask Bonnie on the discussion forum or email Bonnie. And yeah, and we, Sabelo, do you have another question quickly? Are you fine?
No. I was thinking out loud. I'm sitting I'm chairing the panels at Compensation Fund.
Yes.
And the Mutual Association, RMA, and all that. And yes. I'm also on the panel of Dr. Ramukhale, although they have not called me yet. I'm just thinking out loud. I've not applied my mind to it, Prof, that seeing that doctors are under serious threat, because I follow it here and abroad, where now there is a very huge hike in medical insurance on the part of the doctors. And as you are saying, there's over prescription, or what is called as a defensive diagnosis. Were it not how feasible that we were to employ the no fault principle that is employed in the workmen's compensation fee? Is there a legal impediment towards that, so that we take all injuries or deaths that occur under, for lack of a better word, under a scalpel or under a medical care, and have them as you know, in the compensation fund, you've got instruction 157, a toll for this death, and then they've got those calculations if the person was earning and all those things. How far fetched is this thought insofar as trying to arrest the situation from both sides?
It's a good thought, but people don't want to buy in it. If you, right at the beginning, I recommended that you read that Project 33 of the Law Reform Commission, where they investigated it. People feel it will not stand constitutional muster because you're basically taking away people's rights. So there will be constitutional challenges, but before we go into too much detail about that, remember the NHI is coming. The NHI is coming in 2026 if everything is sorted out, and then maybe things will change. The thing is just, no fault. I don't know. If I would like to sue a doctor that does something wrong to me. It will be difficult to get it past our constitutional rights that we have, because it's a little bit of a limitation of your rights.
Yeah, but then the same argument. I just cannot remember the case on top of my head where I just forget the case now. It's a locus classicus where it is said that the employer cannot be sued by the employee. I just forget the section that takes away that right, and we are in a constitutional, yes. Companies like RMA started with mining in the 18 something, and we're in the constitutional dispensation, and there has not been a in fact, there has been a constitutional challenge to the no fault principle, and it has been so to speak defeated. So I do not know what could be maybe the nuance when it comes to the doctors, you know. Because also if you look at the road accident fund, it's a similar setup where we all contribute via fuel. And I have stayed in England where they've got the National Health Insurance. But I could not finish that white paper. It was just too much of a huge document. But if then within same it can cater for that, then my take is that it will go a long way in terms of improving the...
Okay, you know what I'll do? Before the next webinar, I'll do some research, and then I will address it. I will quickly go and do some research and read a few articles and what. And then in the next webinar, I will address this no fault principle. I just want to say, doctors are not angels. Doctors are not angels. And some of them mess up big time. But there's also bad lawyers. There's also bad engineers. But okay, let me do a little bit of research on the no fault principle, the pros and the cons, and I'll address it in the next webinar.
Okay.
Okay, let's see. A doctor is not an employer of a... Okay, that was Good comment by Mario. Yes, I'm gonna research it and then we'll discuss it again. Okay, anyone else? Okay, thank you very much. Have a lovely long weekend. As I say again, contact me. If I can't help, I'll find someone to help. And then we see each other for the last webinar somewhere in October.
All right.
Thank you so
very
much.
Prof.
Thank you. Enjoy the
Enjoy your wine.
definitely. Thank you.
Thank you, everybody.
Just
Thanks,
one
Prof.
loss, ne? Just one loss.
Lovely presentation. Thanks.
Okay. Bye.
Bye.
Bye, Prof.